Next case is KARLING versus Budget Rent-A-Car. And go right ahead.
Morning, Your Honors. I'm Roy Wasson, representing the appellant in this appeal from a dismissal under the Graves Amendment, which is sweeping the state. It's the most popular issue around the state right now. I say that the Florida statutes 324.021 9b and other parts of Chapter 324 are within two sets of exceptions to the Graves Amendment. Some of the cases kind of lump them all together, and I think that's inappropriate. There are two sets of exceptions. There's one set for financial responsibility laws, and there's another set of exceptions for laws imposing insurance requirements or insurance standards. So I'd like to speak first about how Florida law falls within the insurance exceptions to the Graves Amendment. The Graves Amendment says that it does not preempt state laws, quote, imposing insurance standards on the owner of a motor vehicle for the privilege of registering and operating a motor vehicle, and number two, does not preempt state laws, quote, imposing liability on business entities engaged in the trade or business of renting or leasing motor vehicles for failure to meet financial responsibility or liability insurance requirements. And I believe that the section of 324.0219b that imposes additional liability of $500,000 for economic damages on car rental companies falls within both these two insurance exceptions. If the car rental company does not ensure that the lessee has $500,000 in liability insurance, the car rental company is going to be liable for up to that $500,000 in economic damage. So that is a law imposing liability for failure to meet liability insurance requirements. The car rental company does not have that liability if they make sure that that liability insurance is in place. They're capped at the $100,000 under 324.021. So it imposes liability on the business entities. And even if it doesn't impose liability, the defense takes the position in these cases, well, they're already liable they would already be liable under the general dangerous instrumentality doctrine, but for 324.021, and so that's just a cap on the liability. Well, even if it is just a cap and it doesn't impose liability, the first insurance exception is laws imposing insurance standards on the owner of a motor vehicle for the privilege of registering and operating a motor vehicle. It's at least an insurance standard, even if it's not a liability insurance requirement that imposes liability. I want to talk about that first because that seems to me to be pretty clear cut. Most of the cases, they just jump right in and talk about financial responsibility and what's meant by the financial responsibility exceptions to the Graves Amendment. And I'd like to go first to the congressional intent. What did Congress mean by financial responsibility laws? And I take the position that Congress meant that any state that imposed unlimited liability on car rental companies would be subject to the Graves Amendment. But if they imposed limited liability, like Florida does under 324.021, then that is, within the meaning of Congress, a financial responsibility law. And I'll refer the court to the very, very brief legislative history in the congressional record. Two hearings, one took about 90 seconds and one took about 3 minutes, I think. Representative Graves said that his bill was there to correct a situation where he said, quote, a small number of states impose vicarious liability or limitless liability without fault. And similarly, Senator Santorum in the Senate argued for passage of the law, saying it was directed to, quote, only a few states that enforce laws that threaten non-negligent companies with unlimited vicarious liability. So I believe this congressional intent supports the position that a law capping vicarious liability like 324.021 does is a financial responsibility law. It's in the middle of the chapter entitled Financial Responsibility. As section 324.011 says, it says the purpose of the chapter is to provide for financial responsibility. And I'll direct the court to the decision that came out from the 4th District on July the 9th, written by Judge Farmer from the 4th District in Brookins versus Ford Credit Titling Trust. And Judge Farmer goes through it and says in the sentence I underline, says, it is not possible to deny that the whole of Florida law imposes, quote, liability on business entities leasing motor vehicles for failure to meet the financial responsibility or liability insurance requirements under state law. And that's the quote verbatim of the exceptions to the Graves Amendment. Brookins, by the way, is under reconsideration by the en-banc 4th District right now. I got a notice of that recently, and a new opinion is circulating. I don't know which way it's going to go. Whichever way it goes, I suggest that the court should follow Judge Farmer's opinion on that. Before I move to the constitutionality argument, I'd like to just point out that while most of the discussion about the financial responsibility exceptions is centered into 324.021, there are other sections within Chapter 324 that impose financial responsibility requirements and I think are applicable and come into play here, such as 324.031, which sets financial responsibility standards for any, quote, for-hire passenger transportation vehicle. And there's some examples of those kind of vehicles set forth in the statute, including taxi cabs, limousines, jitneys, that sort of thing. But then it goes on to say, or any other for-hire passenger transportation vehicle. There's nothing in that statute that says that it only applies to cars that come with a chauffeur, with a driver. There's no definition of for-hire passenger transportation vehicle. I've cited in my brief a definition of a similar statute that I believe would be broad enough to include rental cars. And if we do fall within 324.031, then the car rental company needs to pick which way it's going to comply with financial responsibility. And if it posts a bond, the bond has to be $30,000 per vehicle, up to $120,000, plus excess insurance of $125,000 per person, $250,000 per incident. We don't know how the defendants in this case, at least we don't know how budget purported to comply with financial responsibility. There's a certificate of self-insurance floating around the record, but I don't believe it lists budget, which is one of the defendants here. So as far as limiting financial responsibility to the $10,000 that is set forth in 324.021, I believe there's a conflict in the statutes applicable to car rental companies. There's a higher limit that the court could find is applicable here, depending upon how the defendants attempted to meet their financial responsibility requirement. Even if we're not within, and I sure hope the court agrees, we're at least within one of the several exceptions to the Graves Amendment, the court should find, as Judge Moore tried to find in the Southern District, that the Graves Amendment is unconstitutional. It's outside the power of Congress under the Commerce Clause. Congress cannot just come in and regulate state tort liability willy-nilly. They are limited. The Commerce Clause permits them to regulate transactions that are, quote, in commerce, those transactions that affect the channels or instrumentalities of interstate commerce.
The 11th Circuit opinion that Judge Kravitz authored seems very persuasive to me on that point. Why do you think Judge Kravitz and the 11th Circuit were wrong?
Well, I just don't believe that every car rental transaction in the world necessarily substantially affects interstate commerce. And I don't think you can have a statute that's so broad that it affects the time when I had to go down last week and rent a car for half a day while my car was being fixed and I had to go to court somewhere else, and it went 11 miles total that day. There was no way I was affecting interstate commerce. There's no it has to substantially affect interstate commerce.
But I don't think the focus is on that individual transaction. If you rented a car from Hertz, which does business not only around the country but around the world, isn't the focus on whether the operations of Hertz substantially affect interstate commerce, not whether your individual transaction did? Well,
The statute, the Graves Amendment, did not provide that it was only affecting those transactions that substantially affected interstate commerce. It would apply to any car rental entity that even limited the rental to in-town driving by Joe's Car Rental Company down by the airport, something of that nature. So if the Congress overbroadly passed a statute that may be effective just based upon its particular facts in a particular case, that doesn't rescue the statute. It's still unconstitutional. It's outside the Commerce Clause power.
Do you have a case that stands for that proposition?
No, we're here. We're on the cutting edge here,
That's what I thought.
Your Honor, I believe. But if they can regulate this, they can regulate where you can park on a village street and every aspect of driving every kind of vehicle, and believe that's just too far of a reach. Our founding fathers, of course, there weren't cars back then, but our founding fathers could not have meant for Congress to be regulating every detail of car rental use. But the court will never get there, because we have the doctrine that if you can address it without having to reach the constitutionality, and you certainly can here, the Graves Amendment does not preempt Florida law under a variety of financial responsibility and insurance exceptions, so I'd ask that the court reverse. Thank you.
Counsel, you got about 7 minutes and 40 seconds left.
May it please the court. Good morning, Your Honors. Philip Platzer for Budget Rent-A-Car, Aesop Leasing, and PV Holding, the appellees in this case.
Mr. Glatzer, how do you address Brookings?
Your Honor, Brookings is an aberration, and I'll explain why. First of all, it should be limited to its particular facts. The Brookings court made it clear that it applies to subsection 1 of 324.0219B, which is the long-term lessor statute. There were about 5 different instances within that opinion where the court limited it to long-term lessor cases. Now, why is that important? For several reasons. First of all, the language in subsection 1 is radically different from the language in subsection 2. If Your Honors were to look at the language in subsection 1, you would see that the words financial responsibility appear in that subsection, and the word requirements appears in that subsection twice. Now, the Brookings court, and I can understand why the court was confused about that, came to the conclusion that because those words appear in subsection 1, financial responsibility and requirements, that somehow or another subsection 1 sets forth financial responsibility requirements for long-term lessors. The interesting thing about that conclusion, Your Honors, is that 17 years ago, the 4th District got it right in a case called Fulmar v. Young, which is cited in Budget's brief. And in Fulmar v. Young, that issue was squarely addressed, because that was when that statute was in its infancy. It had just come into being, 324.0219B. The issue was squarely presented to the 4th District, which was, is that a financial responsibility statute? And the 4th District said, I've quoted the excerpt in the brief, how could that possibly be a financial responsibility statute, the $100,000, $300,000 requirement, when in Florida, financial responsibility is $10,000, $20,000. So the 4th District got it right 17 years ago and got it wrong this time and didn't even mention Fulmar versus Young. Now, because the court wanted to start with financial responsibility, I'll start there too. Just in case, however, I run out of time, because that's a big argument,
Let's go to the other argument, the argument that the courts that have addressed this have ignored the language or insurance standards.
Yes.
And that the statute does, because even subsection 2 does appear to have an insurance standard. If the lessee doesn't have at least $500,000 in combined damage and bodily liability, then the motor vehicle carriers.
Correct. And Judge Lawson, as you pointed out, Judge Kravitz addressed that in the 11th Circuit's recent opinion under a principle of statutory construction, and I won't say the Latin term, but that is that, and you're familiar with it, that you have to look at terms that are closely associated. So it says insurance standards or financial responsibility. Those terms are lumped together. And Judge Kravitz said, when we look at those two together, we come up with the conclusion that what the statute is talking about is insurance requirements. Insurance requirements. Now, there is no insurance requirement in the state of Florida or in any state of the union which would make anybody responsible for having limits of $500,000. It would be unheard of. Nobody could do business that way. Now, if you look at that statute, what that says is that if the lessee doesn't have at least $500,000, then there can be additional vicarious liability on the part of the lessor. It doesn't say that the lessor has to have $500,000, and it doesn't say that anybody is required to have $500,000. And the Graves Amendment is expressed in terms of requirements. Both the Middle District in Garcia, Judge Hodges, and the 11th Circuit focused upon that very, very closely. And incidentally, another decision came out of the Middle District, the St. Paul case, and that was decided by Judge Conway. And in those decisions, all the judges took pains to point out that there is nothing in 9b-2 which requires anything of anyone. 9b-2 is purely and simply a cap on vicarious liability. It's not a financial responsibility law. And I'd like to, if I could, with the Court's indulgence, review the statutes which prove what financial responsibility is in Florida without any doubt. It's not a difficult concept. There's a website on it. The Department of...
Just for fun, what if the...
Yes, Judge.
What if the legislature in Florida decided that they wanted to come up with what they called a financial responsibility scheme directed specifically toward rental car companies, and said that with respect to rental car companies, there are lots of them on the road in Florida, we have a big tourism industry, whatever legislative findings they made, we want to require them to carry insurance of $1 million, and to the extent that they, and sort of tried to get around. I mean, what would your argument be under those circumstances? If it was a clear insurance requirement directed solely to rental car companies, would that take it out of the Part 1, the preemption section of the Graves Amendment? And if not,
without any question, the answer is yes. Okay. And that would be found, Your Honor, I'm glad you started with that question, because I was going to start there myself. We start with 324.021 subsection 7. That's the most important statute of all, because it's entitled, that subsection 7 is entitled Proof of Financial Responsibility. And what does it say? It says that bodily injury insurance limits in the state of Florida, proof of financial responsibility, is $10,000, $20,000, $10,000. That's what it says. So, Judge Lawson, under your scenario, if the state of Florida wanted to make a special financial responsibility requirement just for rental car companies, subsection 7 would be amended, and that's where it would be. Now, let's look at the other statutes which prove the point that financial responsibility in Florida for cars of this nature is $10,000, $20,000, $10,000. This is crucial, and it answers the question without any doubt. 324.031, Mr. Wasson talked about it. What is that statute called? It's called the manner of proving financial responsibility. So we start with 324.021.7 that tells us that it's $10,000, $20,000, $10,000. Now we go to 324.031, which is called How do we prove that 10,000, 20,000, 10,000? It's called manner of proving financial responsibility. And the legislature gave the companies and the individuals in Florida 4 different options of proving financial responsibility. If you will look carefully at those options, they all deal with 10,000, 20,000, 10,000. That's all that they deal with. One of the options for the manner of proving financial responsibility is for a company or a person to have a certificate of self-insurance. Now, we'll do a little show and tell because this answers the question. It's not a difficult question, and there is no doubt about it. Financial responsibility in Florida is 10,000, 20,000, 10,000. The financial responsibility certificate, I deliberately put it in an appendix to Budget's brief. It's the only document in the appendix, and it's the only document that I need to win this argument. What does it say? First of all, it's issued by the Florida Department of Highway Safety and Motor Vehicles, and specifically by the Bureau of Financial Responsibility. And if you look down at the bottom right, you'll see it's signed by the Chief of Financial Responsibility for the state of Florida. Now, one might imagine that the Bureau of Financial Responsibility knows what financial responsibility is in the state of Florida. And if you will look at this document, you will see that what it says is, it's called Certificate of Self-Insurance, and it says that the title holder of this vehicle, which is PV Holding, has responded to the requirements, keyword requirements, of the Florida Financial Responsibility Law. And I'm italicizing the word the. It doesn't say a financial responsibility law. It says the financial responsibility law. Why? Because there's only one. And then it says what that law is. 324.021 subsection 7 for bodily injury, and then it recites the PIP statute too. It doesn't say a word about 324.021 9B2. It doesn't say 500,000 or 100,000 or 300,000. It says 10,000, 20,000, 10,000. Those are the limits of financial responsibility in the state of Florida. Now, while I'm on that point, financial responsibility is a statutory concept only. It is never common law. Every state in the United States has a statutory financial responsibility law, and no state in the United States has a common law financial responsibility law, including the state of Florida. It doesn't exist. If it did, we would see something as absurd as a common law certificate of financial responsibility. When have your honors ever heard of such a thing or seen such a thing? To state it is to realize how ridiculous it is. There's no such thing. It doesn't exist. Now, another statute that's crucial here, and probably the most crucial of all, because this is where the rubber meets the road, 324.051. That's the suspension statute. It tells us how our license and how our registration can be suspended. And if you will look at that statute, what it says is, following a crash, they don't use the word accident, they use the word crash, following a crash, the license of an operator, the registration of an owner will be suspended, shall be suspended, it's mandatory, by the Department of Highway Safety and Motor Vehicles unless the owner or the operator have complied with 324.031. We're back to that one, the manner of proving financial responsibility. So we either have a liability policy for 10-20-10 under 324.031, or we have a bond, or we have a self-insurance certificate, or our license is suspended for the operator, or our registration is suspended for the owner. That's the most important statute of all, because that is what tells us what financial responsibility is. Now, if financial responsibility for the privilege of registering and operating a motor vehicle were $500,000 or $100,000, $300,000 for rental car companies, to answer Judge Lawson's question from a moment ago, that would be in that registration suspension statute. It would say, rental car companies, guess what? For everybody else, it's 10, 20, 10. But if you don't have $500,000, or if the lessee doesn't have $500,000 or 100,000, 300,000, those numbers that are in 9B2, then your registration will be suspended. It doesn't say that in 324.051. That proves the point that that is not financial responsibility for rental car companies. And you know what? It's also not in 324.031 for manner of proving financial responsibility. It doesn't say rental car companies, there's a different manner of proving financial responsibility for you, and it's $500,000 extra liability for you. No, it's not in there. Now, that takes us to another Latin maxim of statutory construction, and this time I will tackle it because I know how to say it. Expressio unius est exclusio alterius. We all know what that means. When the legislature has spoken, when it has enumerated certain matters within a statute and excluded others, it's presumed that those other matters were intended to be excluded. So, when we look at 324.0217, proof of financial responsibility where it says 10, 20, 10, and we don't see $500,000 there, it's presumed that that was intended to be excluded. When we look at 324.031, manner of proving financial responsibility, we see all the different manners. We don't see $500,000 there. It's intended to be excluded. That's not a manner of proving financial responsibility. When we look at 324.051, which tells us how an owner's registration can be suspended for not having the requirements of 324.031 in place, we don't see $500,000 in there either. It was intended to be excluded. There is no such thing in the state of Florida. It's preposterous for anyone to conclude that a rental car company has to insist that a renter has $500,000 in insurance. How many rental cars would ever get rented if that was the law? I dare say probably none, or close to none, because who has $500,000 in liability insurance?
Let me ask you to address
Yes.
this question. That is maybe a little long, but I think the Brookings panel will probably say that you're crafting a very good argument for why financial responsibility and insurance requirements should be sort of narrowly construed in their view. But the U.S. Supreme Court says that preemption statutes are supposed to be narrowly construed, and therefore exceptions should be broadly construed, and because of that, you should read financial responsibility in its broadest sense, perhaps. I think that's what they're saying in Brookings. And if you read it in its broadest sense, then you could certainly make an argument that the Florida statute we're talking about is a financial it talks about insurance. It's a financial responsibility or insurance statute.
Right.
I think that's sort of the gist of what the Brookings panel was saying.
Right, and that's why they got it wrong, because you see, when we look at Black's Law Dictionary, and this was pointed out by Judge Kravitz, it was pointed out by Judge Hodges, it was pointed out by all of the federal middle district judges who considered the issue. Black's Law Dictionary tells us what financial responsibility means. It's a state statute prescribing the minimum limits. In every state, it's exactly the same. I've given you in the brief several states as a little sampling of what financial responsibility is in the 50 states. I stand before you today and represent to you that in every single state of the United States, it's exactly the same. It's a state statute with different limits. Some have 1530, 2550, 510. All the states have a difference in limits, but in every single state, financial responsibility is statutory, not common law. And 9B2 is a cap on vicarious liability as admitted by KARLING in his brief at pages 9 to 10. Vicarious liability doesn't translate to financial responsibility. So Judge Lawson, we can read this. I'm willing to read this as narrowly as possible. And then I get back to what the 3rd District said in Coomersing, that the statute unambiguously preempts the state statute. And then I get back to what the district court judges said here in the Middle District. They say that the Graves Amendment expressly preempts the state statute. And that is true because when you look at the language of the Graves Amendment, no matter how narrowly you wish to read that language, it says that no owner who rents or leases an automobile shall be liable solely by reason of being the owner. That's vicarious liability. So you can read it as narrowly as you want. You come back to the same conclusion. It's unambiguous. The legislature intended preemption. Now, I'd like to point out to you, if I may, the decision of Judge Kendall Sharp in the Dupuis case, D-U-P-U-I-S versus Vanguard, and that is cited in the brief. And Judge Sharp said that it is not permissible for us to even speculate as to what the intent of the Graves Amendment was, because it is just completely clear on its face. Here's what he said. As the meaning of 49 U.S.C. 30106 is clear from the statute's language, no further interpretation is required or even allowable. The Graves Amendment is a clear expression of congressional intent to preempt Florida's dangerous instrumentality doctrine as applied to short-term motor vehicle lessors. I don't think that it could be any more clear than it is as to what the legislature intended, but we go by the statutory language and we come up with the conclusion that the 3rd District came up with in Kumar Singh. Incidentally, the 1st District agrees with Kumar Singh. It issued 2 per curiam affirmances with no opinion, citing Kumar Singh and Garcia and nothing further. And since that was the only issue in Kumar Singh, we know that the 1st District agrees with what the 3rd District did. So does every single court in Florida. There isn't a single court in Florida who has looked at subsection 2, which has said that there is no preemption. Every court has come to the conclusion that there is preemption. Every district court judge, United States District Court judge, and every appellate decision has said that there is preemption. Now, my time is ticking away very fast. I wanted to say that Mr. Watson relied upon Judge Moore's opinion. Judge Moore's opinion is history. It's gone. It's forgotten. It's over with because the 11th Circuit in Garcia did away with it sub silentio, another Latin term, without mentioning it, and it's gone. It's finished. So we can't rely upon that anymore. So we do not have a single decision holding the Graves Amendment to be unconstitutional in the state of Florida. There isn't a single one. Huchon and Druin, those 2 decisions from Judge Moore, they're gone. They're simply gone. Incidentally, I wanted to point out to the court that Brookins, you asked me about Brookins. The Brookins court thought that the 11th Circuit was never going to pass. It said it was dismissed.
Counsel,
so, okay, I understand, Judge. I'll bring it to a close, and I thank you for your attention. I ask you to affirm the trial court in all respects and uphold the application of the Graves Amendment in this case.
I have one quick question.
Absolutely.
I don't recall reading a case that was authored by Judge Conway out of the Middle District. Do you have the name of that case?
I certainly do. It's cited in the brief, Your Honor. It's a very important case. It's called St. Paul Fire and Marine Insurance Company versus, and if I change glasses, I can tell you it's versus Lee. It's not a Graves Amendment case, but it discusses the Graves Amendment in great detail. Okay. Thank you very much once again for your attention, and I ask you to affirm the trial court.
Mr. Watson, you have 7 minutes and 41 seconds left, and I want to point out that you're down by 2 Latin expressions to none. So we're expecting a lot of Latin expressions from you on this, since you're down 2-0 on this.
Yes, Your Honor. I'm at a disadvantage because I never took Latin. But I think there must be a Latin phrase for a point I'd like to make here. Counsel argues that the Congress did not mean what it said when it set forth 2 different kinds of insurance exceptions here under subsection B 1 and 2 of the Graves Amendment. One of those is an exception for state laws, quote, imposing financial responsibility or insurance standards, and the other one is the exception for laws imposing liability, blah, 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 or liability insurance requirements. So he says that when you say standards in one paragraph and requirements in another paragraph, you mean the same thing, and there's no requirements under Florida law. And I say there must be a Latin phrase that says where the Congress says standards in one paragraph and requirements in another paragraph, it must mean 2 different things. And so even if there's no requirement which I disagree with, there is certainly a standard by which the car rental company is going to be held liable for $500,000 in economic damage if the lessee does not have that insurance. But I say it's a requirement. It doesn't have to say in a requirement that here's what the punishment is going to be if you do not comply with this. But it essentially does. It says that if you do not make sure that the insured has this insurance, you're going to be liable. It doesn't have to say we're not going to issue your registration or your tag. It's a requirement that has a method of enforcement, but it's also a standard. On the issue of the $10,000 under 324.021 being the sole manner of financial responsibility and proof of financial responsibility, this is very confusing. You've got to look to 324.031, which sets forth a variety of means for complying with financial responsibility. They say that the method that they did it here was by posting a certificate of self-insurance. It's in the record. It's on page 588. It does not include budget. Budget is not here. Budget did not comply with financial responsibility in this method. Okay? If they didn't say they had a $10,000 insurance policy anywhere, if they didn't comply with financial responsibility requirement in one way or the other, they're not capped at the $10,000 in liability. I would ask that the court reverse the dismissal. Thank you.
All right, thank you, counsel. We'll take